If you are an unwed mother in Florida and you are thinking about filing for an order of protection against the abusive father, watch this video. There are two ways filing for an order of protection can end up trapping an unwed mother.
It's a trap!
One, if the father is not on the birth certificate and there has never been any sort of establishment of paternity, no child support, no custody order, no custody case ever filed, and you file for an injunction for protection against domestic violence, that can turn into a custody order. And the relocation statute applies anytime a custody case is filed or a custody order is entered. You cannot relocate outside of 50 miles without the other party's written consent or a court order granting a relocation. But if you are an unwed mother and the father of your children abuses you and you file for an order of protection in Florida, the abusive parent now can control whether or not you're able to flee to safety with the children. The other thing an injunction will do is enter some sort of time sharing. The Florida legislature somewhat recently made it much easier for unwed fathers to establish legal paternity. For example, if they're on the birth certificate, that usually requires some sort of acknowledgement of paternity also being signed by both parties at the hospital. There is a presumption of paternity, and it will be very easy for the unwed father to establish paternity. That can happen in an injunction. I have seen it happen several times where an unwed mother files a petition for an injunction against domestic violence against an abusive father. There's no custody order. He is on the birth certificate, but there's never been any time sharing order. There's never been a paternity case filed. In that injunction, the judges are establishing paternity and giving the father time sharing. That means that if you file for an injunction against an abusive father, you will very likely be ordered to share some form of custody with that father. The best interest of the child is still the standard that applies to any sort of custody order, whether it be in an injunction or not. And the other kicker is that the 50-50 presumption also applies even in an injunction. The court is supposed to consider evidence of domestic violence. Of course, we're there because of evidence of domestic violence. But I have absolutely seen situations where a final judgment of an injunction is granted against a father, and that father is then given 50-50 unsupervised visits with the children in that injunction. There are plenty of times where I have a client come to me saying they want to file for an injunction, and I tell them that's not a good idea. If you are not married, and especially if you are thinking of fleeing the state for your and your children's safety, and you are also thinking of filing for an injunction for protection in Florida, I would think twice and I would absolutely consult with an attorney before you do anything like that. Safety is the point, right? If we're filing for an order of protection, the point is that we want to be safe. Sometimes that's not the safest option. So it is always a good idea to talk to an attorney, consult with a domestic violence advocate, come up with a safety plan, and figure out your best route to escape, both legally and practically.